Okay, ready to go when you are.
May it please the court, my name is Michael Waslick. I am here on behalf of the appellant Leonardo Di Giovanni, and with the court's permission, I'd like to reserve 5 minutes of time for rebuttal.
Sure.
Thank you, Your Honor. The court may be experiencing deja vu. As the briefings have indicated, there is a case from 2017 that this court decided, Di Giovanni versus Deutsche Bank, which involved the same participants, the same homeowner, the same original lender, the same bank, the same standing issue, the same loss note procedure, and the same documents.
But counsel,
yes, sir.
But the facts are significantly and materially different in that case and the one before us. Would you agree with that?
I agree that there are some differences, and for the reasons that I'm about to go into.
I use the word significant. Do you agree with that?
There are some differences that are, depending on how you interpret them, they could be significant, absolutely. But I don't think they compel.
I mean, in that first case, there was judicial behavior that was surprising. Would you agree?
I would agree that.
Do we have that in this case?
I think we still have the categorical interjection of the trial judge into the proceedings, which is different in its nature, but is still the same type of participation that's prohibited by the case law.
Well, okay, except for in the first case, the judge sort of went out on a mission of his own, right? He went himself onto the internet during a break in his own effort to prove this linkage that you are challenging here today. And he not only came up with the information, he kind of directed, the bank's attorney how to proceed. Isn't that true?
That's true. In that case, that is what happened. And in this case,
and that did not happen in this case, correct?
The trial judge did not go to those same extremes,
Okay.
but did actually suggest the judicial notice after the bank's trial counsel had rested and waived any further introduction of documents. So we, again,
Okay.
categorically, we argue it's the same, even though there are some detailed differences that make it less shocking, but still fall within the category of conduct that we think is an issue here. But there are other reasons as well, besides the trial court's injection of itself in the proceedings. There are multiple other reasons why this case should have the same result as the prior Di Giovanni case, and that is this. The original case remanded for an entry of an order of dismissal, and we believe that that's also appropriate in this case. The main themes that this court brings to that this case brings to the court are the propriety of judicial notice, both in principle as it's applied here, but also in its implementation. And then secondly, the issue of having to prove a negative under the statutorily required scheme to reestablish the lost note, as when it's done in this way with a witness who, because he's merely a records custodian, lacks personal knowledge of the underlying facts, and the records do not one way or the other dispose of the factual issue that must be proven. And so when you look at both of those issues, it's our contention that both of those issues require a remand for dismissal. As for the judicial notice, there are 3 fatal defects in the way judicial notice was handled in this case. First of all, the matter that was noticed was not the proper subject of judicial notice, which I think is on all fours with the prior Di Giovanni case. Secondly, there was a lack of proper notice as required by statute for the request for judicial notice, which was filed at 3:52 p.m. the day before a 9 a.m. trial in violation of the court's own trial order. And then—
So how much, counsel, how much time is enough time?
Well, in this case, Your Honor, the court had a trial order that required 10 days. And I think if the bank had participated in a way that cooperated with that 10-day requirement, there wouldn't be an argument here. As it stands, the record shows that trial counsel for defense didn't even know about the request until showing up that morning, because presumably he'd finished preparing for trial the day before.
I always have a hard time with that sort of explanation, because that sort of encourages lawyers not to check their email and things and say, well, I didn't know, So, and I guess I'm hearing you talk about the 10-day sort of thing. Is there anywhere in the law that gives a time frame? I mean, are you just picking the 10 days out of the sky, or can you hang your hat on something?
There's no express time limit for a judicial notice request. It is dependent on the circumstances and the facts. In this case, the facts and circumstances are that the trial court has discretion to order disclosure of evidence, and in this case chose 10 days, which neither party objected to. And I think where you
And
have
doesn't the judicial notice, the no firm deadline, doesn't that align with the substantive law on judicial notice, which is that judicial notice is really supposed to be reserved for things that there's just no argument over, you know, what the stock market closed at the close of business on January 1st, 1985, or whether it rained in a certain area. Those kinds of things that you can go to a ready source. There's no dispute about the authenticity of the source or the relation of the fact from that source.
It does. And the reason for the timely notice requirement in the statute, as I understand it, is to allow the parties and the court to determine whether or not that matter is a proper subject for judicial notice. And it's something that's very important to recognize, that this specific institution history and this specific website were the same ones found in the prior DiGiovanni case to not be a proper subject to judicial notice. And had trial counsel had proper notice of that, he could have made perhaps a better argument, although I think he did the best he could under the circumstances, a better argument about why that particular document was not a proper subject to judicial notice, because of the lack of authentication and the lack of overcoming the hearsay component of it. Because in this case, the institutional history did have, and the evidentiary portion that's relevant to this case is a statement that an institution supposedly changed its name. And the cautionary tale that the DiGiovanni 1 case talks about judicial notice is it because it essentially shortcuts the party's right to present evidence on issues, that it should be approached with great caution. And this case is particularly applicable to that principle, because if an institution that is appearing as a party before the court, in this case Deutsche Bank, had changed its name or merged or had some other corporate event happen, the best evidence of that event is its own records. Why would it not produce its own records authenticated by its own records custodian, instead of having to reach out to an external source?
Well, there's no question that certainly would be the better plan. I mean, there's no argument there, but we sort of have what we have here. And what's unique about this issue and this case, as you correctly pointed out, the previous Giovanni case had the exact same issue, exact same parties, exact same name change. So for you to argue you were surprised is a hard one, because 2 years earlier, you fought the exact same battle with the exact same institution and the exact same name changed. So it's really hard to sort of say, gee, you know, we got this the night before. We didn't know this was coming. You knew it was coming 2 years ago.
Well, first of all, I was not trial counsel.
I understand you weren't trial counsel, but that case is of record.
Yes, Your Honor.
And you certainly know of that case, and you certainly know of this issue.
And Judge Morris is using the generic view.
Fair enough. And the issue there, Your Honor, is that the DiGiovanni 1 case did not come down until after the trial had concluded. In this case, I think the record shows that that's the timeline. So the issue that
that's a good response. I didn't really pay attention to that.
Well, and I'm grateful for the opportunity to clarify that. The issue in this case that was surprising was the manner and timing of the request for notice, and the attempt to again use that external source to prove something that really should have been disclosed at the minimum 10 days beforehand, which it would have been if it were a proper subject of, for example, business records.
Well, the reason why the other case is important, and the fact that this issue was there, is it's a question of prejudice. I mean, how do you claim prejudice if you knew about this 2 years earlier?
Well, because again, trial counsel prepares the day before trial based on documents that are disclosed, presumably within the 10-day requirement on the trial order. It appears that everything else was. Why would the bank wait until the last minute if it wasn't attempting to prejudice them, or if there wasn't some kind of oops at the last minute that they realized they forgot to put something in? Trial counsel's entire case was altered by this fact, and we addressed the prejudice a little bit in our briefs. The idea is that the defendant is preparing for a trial based on certain disclosed documents, and suddenly the entire theory of the case changes. How is that that is not something that the case law suggests is fair to either party. If a foreclosure defendant had come in at 3:52 the last minute producing a document that was dispositive of a major issue, the bank would have rightly objected to that, and an objection would properly be sustained because that is trial by ambush. And I don't think that it's fair for either party to be able to do that, especially when there's a trial court order requiring the disclosure more than 10 minutes before, or more than.
Shift gears on you, because I don't want you to run out of time. And what I want to ask you is an issue that many times is not thought to be discussed. You're claiming attorney's fees in this case, and I can't find a basis for you to get them. Have I missed something?
Well, Your Honor, if the court decides that the plaintiff lacked standing in the trial court below, I believe that there would be a lack of basis for attorney's fees in this case.
Okay. Well, I mean, typically you get them, or the only way you get them is there's a provision in a contract that says that there's some sort of addressing of attorney's fees, or there's a statute involved. And I'm having a hard time seeing that in this case.
Well, if the a court determining that standing was lacking or the contract was not reestablished, I think would dispose of the attorney fee issue.
Okay.
Does that answer the question sufficiently?
Okay. All right. Thank you.
We've touched on the notice issue. I think that the last issue with the judicial notice is the waiver issue. Here the bank rested, informed the trial court it had no further documents, no further exhibits, and only after taking the matter in advisement after a recess, then came back and said to the trial counsel, didn't you have a motion for judicial notice? A motion which the bank had not sought a ruling on during the actual case in chief. And so that's the nature of the participation that we believe is prohibited by the case law. Going to the second issue.
In the standard by which we have to view this as abuse of discretion?
Well,
I mean, a court's granting a motion to reopen a case to put in some incidental proof, which this really would be, because the motion was out there, everybody knew the issue was in play. Isn't that basically, we have to determine that no reasonable judge would have done what this judge did?
Well, I think that is an abuse of discretion where at the conclusion of its case, a written motion that's filed and then not where there's no ruling sought. Again, a foreclosure defendant who does this is deemed to have waived anything that they didn't seek a ruling on. And that's the Baker case that we cite in our brief. And so it's the sauce for the goose is sauce for the gander. If the bank brings a motion but fails to obtain a ruling, rests, and then it doesn't seek a ruling until after the trial court comes back and suggests it should, I think that's an abuse of discretion. I think that's not reasonable for the trial court to do under these particular circumstances. The issue I'm going to transition to next, if there's no further questions, is the issue of proving a negative. Here we have the required elements of the lack of waiver or the lack of transfer or seizure. And the method in which that was attempted to be proven is not legally sufficient, because what you have is a witness with no personal knowledge, because he doesn't claim to have been and wasn't involved in the circumstances surrounding the loss of the note. So he doesn't have that information from firsthand percipient observation. And then secondly, the records that are available to the trial court, the records that the bank has provided to the trial court, don't establish one way or the other whether that happens. There's really only two ways to prove that negative. One is to prove some other affirmative alternative set of facts. So for example, a bank could come to court and say, we know that the note was lost in a fire. Here's the evidence of the fire. And that would be sufficient proof that it was not a seizure or transfer. Or it could be, depending on the circumstances. I can think of circumstances where it might not be, but you can prove that there was an alternative set of circumstances to explain the loss of the note. The other way is guided by the Puig case and 90.803 sub 7, which talks about the absence of an entry from business records. And in a roundabout way, the bank attempted to do that in court, but failed, because it did not lay the statutory foundation for that testimony. In other words, like the Puig case, where they involved phone calls and the witnesses essentially said, we don't have any record of phone calls being made. That was insufficient to prove the phone calls were not made, because they didn't say that there would have been a record of those phone calls and that the record was lacking that particular series of phone calls. Similarly here, there was no testimony that the bank does anything to track loss of the note through seizure or transfer. There was no testimony of any type of record keeping system, any type of correspondence log or event log that would have noted such. And what would have been sufficient is that the bank had said, this is how we track seizures and transfers. Here's that document. There's no entry in this document for such an event. Had there been—
Look, you're down to your 5 minutes. Use them as you wish.
Thank you, Your Honor. So because there was no foundational testimony for anything under 90.803 sub 7, that testimony, the blanket testimony by the witness at the bank at the trial was legally insufficient to prove the negative. And so that is also under Correa a fatal flaw. With that, I will yield the rest of my time.
Okay, you're up. Ms. Rios.
Good morning. May it please the court. Shai Brios on behalf of the appellee. I will start with Mr. Waslick's last argument, which was with respect to whether the bank proved or reestablished, there was sufficient evidence to reestablish the lost note. And beginning at the transcript on page 43, there is evidence and testimony by the bank's servicer indicating what the bank's procedure is for when a note is lost. And it didn't go into tremendous detail. However, it did outline generally what the procedures are that are followed, including, and there was testimony that the bank would, for example, contact counsel to see if the note had been sent to counsel, review a court file to see if a note had been filed. And so that, coupled with the exhibit that was admitted into evidence indicating that Bank of America had received the original note specifically endorsed to Bankers Trust, coupled with the assignment of mortgage that was admitted into evidence indicating that both the note and mortgage were assigned to Bankers Trust. It's the bank's contention that that testimony supported by the evidence indicated that there was no seizure and no transfer. And I did want to address
help me out, counsel. That just doesn't, to my mind, that just comes nowhere near the mark. I mean, all that needed to happen was just put on a witness who could competently state, we had the note as of this date. I can definitively state that it was in the possession of this company, this attorney, whatever, but now it's gone missing. No one says that.
That's true. There was no testimony to that effect, Your Honor. However, there was an exhibit introduced into evidence which indicated that Bank of America had in fact received this original note endorsed. And that was, I believe it was.
But that doesn't, all that just says is that, okay, we had it, but the key part of the lost note claim is that we had it and we either lost it, and then also, by the way, it wasn't transferred or seized. And that's just none of that's there.
I believe that there was testimony elicited once the plaintiff asked, at the conclusion of defendant's motion for involuntary dismissal, plaintiff asked to reopen its case. And the judge granted that request, which is a discretionary decision. And there was testimony.
Now you're talking about the identity. That's the issue of the identity, right?
No, this was evidence regarding the seizure and transfer. This was at page 93 of the transcript.
Okay.
As to the element of the lost note, if the court would permit, simply plaintiffs to allow plaintiffs to reopen its case and elicit testimony regarding the seizure. And essentially what the bank representative testified to was that in his review of the bank's records, including—
Oh, right. The records I have with me don't indicate that there's no transfer or seizure, which to my mind, again, doesn't state anything. I mean, if I showed up with a bunch of papers and you asked me, hey, Judge Lucas, have you ever had a traffic ticket? And I said, well, I brought these papers with me. It's my college transcript and it's my bar records. And according to them, I've never gotten a traffic ticket. You'd say that you've not proven anything, right? I mean, that's kind of this. I mean, you've got, yeah, you do have some business records there. Witness has them, but there is no testimony that says these records would show if there had been a transfer or there had been a seizure. That's never says that, right?
That is accurate, Judge. That is accurate. And I guess I would frame this in the context of this was a motion for involuntary dismissal. And so I think the trial court is also at this stage, it is not supposed to weigh evidence, measure the credibility of a witness, and facts are to be taken as true for the non-moving party. And so what I would suggest to Your Honor is that unlike in Correa, there was some evidence, certainly not ideal, but there was some evidence that was admitted via testimony as well as supporting documents. And there was nothing to suggest, I think the language that was used was, there was nothing to suggest one way or another, whether there was a transfer or seizure. I think at a motion for involuntary.
But that's your burden. Under the statute, the lost note statute, you have to show that. I mean, unfortunately, the way the statute is set up is, as your friend on the other side says, you do have to prove a negative, but that's baked into the statute. That's your prima facie case. So if it's well, the evidence didn't show it, one way or another, whose fault is that? I mean, I'm not sure this is an example where you could say, well, we had some evidence that suggested that the note was not transferred or seized, and other evidence that suggested it was. There's just nothing here.
I understand, Your Honor. Are there any other questions with respect to the reestablishment? If not, I will move on to the judicial notice issue.
Counsel, when you proceed into that, would you concede at the outset if this internet printout was not a proper subject, put aside however it was previously noticed, but just the internet printout just is not a proper subject for judicial notice? If that is true, would you concede our prior DiGiovanni decision compels reversal here?
I apologize, Your Honor. Can you repeat the beginning of that?
Sure. No, fair enough. Just cutting right to the substance of what it is you are seeking judicial notice of. All right. Sure. You found this database, you pulled it up on the internet, you printed it out. According to this printout, you had a name change. This company had a name change at some point, right? If that subject and that printout is just not a proper thing for judicial notice, would you concede that the prior DiGiovanni case controls here?
If it wasn't proper, yes, I would concede that prior DiGiovanni would be controlling. However, okay. I believe that the argument is a bit nuanced. And there's also a factual distinction that I would like to point out. In the prior DiGiovanni case, the judicial notice, not only did the court take judicial notice of the printout, following the court's independent research, but that was admitted into evidence. In this case, the trial court took judicial notice of, well, here's where it's nuanced. The trial court took judicial notice, but the document was never admitted into evidence. In fact,
you're going right to where I was going. That's exactly this wasn't even admitted in evidence.
Correct. It was not admitted into evidence. And I think the reason why the first DiGiovanni case is not necessarily dispositive of this case is because I believe, so this goes to what I think you were asking me initially and why I was very careful about that first part of the question, is I believe that the court could take judicial notice of the fact that this Federal Reserve website reflected that Bankers Trust, historical name change, or Deutsche Bank's historical name was previously Bankers Trust. What I would also suggest, and this was something that was raised within the reply brief regarding why the appellee's answer brief was essentially centered around the authentication of the document and not whether it also was subject to admissibility under a hearsay exception. I think the nuance is that the bank contends that this is non-hearsay. The document, and it wasn't admitted into evidence, but it would not have been a document admitted for the purposes of the truth of the matter asserted. For example, Deutsche Bank, or it was formerly known as Bankers Trust, but I believe, and this is nuance, I believe that the court could take judicial notice of the fact that this website, the Federal Reserve, reflected that this was the historical name change. And I will.
Well, but I mean, I'm sorry, I'm having a hard time understanding your right. We were not trying to offer to prove the truth of the matter asserted, but you could take judicial notice that this website reflects that, in fact, this name change occurred, which by the way, is what we're trying to prove for purposes of showing our standing today. How do you reconcile those?
Well, I think it's some evidence. Again, I frame this in the context of a motion for involuntary dismissal, and I would point the court to even the footnote within the first DiGiovanni case, which indicates that, the National Information Center is a central repository of data about banks and other institutions for which Federal Reserve has a supervisory, regulatory, or research interest. And I think something similar to the point I'm attempting to make is brought up in some of the other cases, but essentially the court can take judicial notice of that fact without introducing a document into evidence. And that is what I'm trying to say.
But that does, okay, fine. So the court takes judicial notice of the fact that there's this Federal Reserve database and it does this thing. Great. What does that get you for purposes of proving standing?
Well, in this case, the court, I believe, is permitted to take judicial notice of the fact that the Federal Reserve reflects the name change.
Right,
Again,
it proves the truth of the matter you're trying to assert, which is that this name change occurred and thus we have proper standing.
I think that it is evidence.
Okay.
It can support it. And again, at a motion for involuntary dismissal, I think the burden would be then, on the defendant to show something that, for example, it's unreliable. I mean, this is a government website, essentially.
Right. It is, I guess.
Sorry, Your Honor. Let me just find my place. With respect to the reasonableness, I think the bank would concede that it would have been more appropriate to have more time, but I think as Judge Morris indicated, they were aware of this document. Trial counsel below was both trial and appellate counsel in the first DiGiovanni case, and so I don't know that this would rise to the level of shock or trial by ambush, while conceding that it should have been made prior to the eve of trial.
Well, Kat, I don't mean to be picking on you, but I just want to flip that coin because there's another side to that. The same issue came before your client as well. An argument could be made. Wait a minute, you knew that you needed to prove up this name change, and yet you didn't. Nobody thought about it. Whoever was your trial counsel below. Nobody thought about it until supper time the day before the trial. Didn't have a witness that was ready to prove what should be a pretty easy point to prove about this name change. Instead, try to pull something off the internet, get judicial notice in, kind of the last second. I mean, it just seems like this was a case where the bank knew about this issue was going to need to prove, but just wasn't ready when trial time came up on it. Why should that be rewarded in the context of saying, well, you know what, it was an abusive, let's allow the trial court to suspend its deadlines, ignore the customary time that we would require for judicial notice. Why should that be engaged in? Why should that be countenanced?
Well, I don't know that the bank should necessarily be rewarded, but I think it goes back to the idea of prejudice, right? I think that if there isn't any prejudice articulated, then there is no issue. I also think that it supports the policy of the courts to adjudicate on the merits. And so if there is no prejudice set forth, and articulated, I think that the judge has discretion, and in this case, exercised it well in allowing the judicial notice in an attempt to adjudicate the case on the merits.
Well, I think what your friend on the other side suggested is that, hey, the prejudice we had was that, look, up until 6:30 the evening before, was prepping for trial, looked like the bank was going to come up short on its prima facie case proving standing, and now all of a sudden they're trying to change things with this internet printout. We're going to have to argue about judicial notice, and I can't get ready to talk about judicial notice when they never brought that motion before the until the evening before. I think that's what I'm understanding what the other side is saying. How about that notion of prejudice as far as preparing for trial and being ready to go?
Well, I think that I would have to concede that it possibly plays into settlement, for example, settlement discussions. I don't know, I think what counsel had indicated is that it changed the theory of the case. I don't agree that it changed the theory of the case. I think it implemented, it added some evidentiary issue, which again, I would have to concede when you're looking at your case, maybe that would have informed settlement negotiations or something if I said, hey, I know I'm going to be able to do this, but it certainly did not change the theory of the case. And again, while, what's good for the goose is good for the gander, I understand that the plaintiff was aware because the plaintiff was involved in the prior DiGiovanni case. I don't know if the same trial counsel was, notwithstanding that fact. Again, I don't think that this is a classic case of trial by ambush or total shock and surprise. I mean, I think that they were able to voice an objection. They're familiar with, trial counsel was familiar with this issue, and in fact, familiar with this specific document. And I don't know that it's fair to say that, this issue was tried by ambush. I mean, essentially, if you take a look at the first DiGiovanni case, and I will try to wrap this up, basically the final judgment was reversed because the court undertook independent research. The court prompted Deutsche Bank to reopen its case and admitted the document into evidence. None of those facts are present here. And I guess I don't want to circle back to the front, but one thing I did want to make a point of, because it was also raised in the briefs, is that the plaintiff had waived this. I disagree with that because, one, in the transcript, it is very clear to me, and this was cited within the answer brief, the plaintiff brings the request for judicial notice up within its case in chief, and this is in the transcript at page 34, lines 9 through 21. Now, ideally, counsel would have waited for a ruling, perhaps before the close of evidence, would have recalled that and asked the court to make a decision. But I think that its conduct in raising that issue does not support the fact that plaintiff was intending to waive that. And I think that the judge in a non-jury trial is permitted to, at a recess, determine whether all rulings have been made, even if plaintiff has rested, noting that this request for judicial notice, which had been brought up, raised in the case in chief, had not yet been ruled upon. I think the court was within its discretion to say, hey, we still have this outstanding issue. Are you are you planning on going forward with it or not? I don't see that as being a problem. So for those reasons, and because of the factual distinctions here, the bank respectfully request that the court affirm the final judgment that was entered. And if there are no further questions, I will conclude my argument.
Thank you, Ms. Rios. Mr. Waslick?
Thank you, Your Honor. It's apparent to me that the court clearly understands the issues before it. So unless there's any other questions for me, I'm just going to simply rest on my prior argument and the briefs and request that the court remand for entry of an order of dismissal.
No one ever gets penalized for not using all their time, Mr. Waslick. Thank you both very much.
Thank you. May we be excused?
Oh, absolutely.
Thank you.
Our next case is, I can find it here.